I want to talk to you about this fully informed jury association and jurors' rights. It's a very important issue that the folks over at the Wilkes-Barre Independent Gazette have brought to the forefront, and I'm very proud of their work. On Sanity Check on Saturday mornings at 7 o'clock, they take all comers. They talk about all kinds of issues. In the Wilkes-Barre Independent Gazette, which is associated with that, Mike Lacey, Tea Party Mike, and Lou Jasikoff, Libertarian Lou, put together Sanity Check. They also, with a big team of people, put together the Wilkes-Barre Independent, which Lou always reminds me, make sure you tell people it's coming to Scranton too. There's going to be a Scranton edition. And they're doing some amazing independent journalism. And one of them is they are driving the agenda. And I'm so excited about this because it is exasperating to me that with 4% of the American people saying gun control is a priority, we have the most conservative senator perhaps that Pennsylvania has had in a generation on the wrong side of a gun issue, when only 4% of Americans think it's a priority. We ought to be driving issues like the Wilkes-Barre Independent Gazette is and asking the right questions. And what they did was they put together a great letter, and it's posted on our Facebook page and on their website. And they took it down to Judge Thomas Burke, Judge Jennifer Rogers, this is Luzerne County, Judge Michael Vowell, Judge William Amesbury, Judge Tina Polachek, Gartley, Judge David Lupus, and the rest of the judges down there, and in fact the district attorney. And they said, we want to know what your position is on fully informed juries. And here's the letter. They said, and I like the way they did this, our Wilkes-Barre Independent Gazette May issue, hitting the streets May 7th, will include a full-page article on jurors' rights and jury nullification, what nullification is and how it works. On June 18th, 2012, New Hampshire Governor John Lynch signed into law House Bill 146, which states, a right of accused in all criminal proceedings, the court shall permit the defense to inform the jury of its right to judge the facts and this is the key, the application of the law in relation to the facts in controversy. This, of course, their letter goes on, and this was the letter they hand-delivered to all the judges last Friday. And, in fact, when they talked about it on the show a week ago and then went down, they told me that at least one of the judges said, oh, you guys are here. We've been waiting for you. We heard about your letter. We heard you were coming, and we were looking forward to talking to you. So they're listening in the halls of power to the show, and they're not necessarily thrilled with it, but this is the beauty of this show and your engagement and others like it, the Wilkes-Barre Independent Gazette and Anthony Antonello and all of the independent journalism that's springing up here in northeastern Pennsylvania. A very exciting time for reform of media. And the judge said, we're talking about this. We want to know what you've got. And here's what they've got. The essence of jury nullification. Throughout the United States, judges have forbidden defense attorneys from informing juries that they have a right to nullify the law based on their dislike of the law. For example, a defense attorney in California who argues on grounds of nullification could actually face disbarment or other sanctions by the court, even though nullification is a right of all U.S. jurors under common law. And then they go back to the Founding Fathers. And I just think this is a really well-constructed argument. It was none other than John Adams who said about the juror, it is not only his right, but his duty to find the verdict according to his own best understanding, judgment, and conscience, though in direct opposition to the direction of the court. It was John Adams' view, according to this quote, that the ultimate arbiter of the law was not the judge, but the juror. Something that we have lost in our era of experts. That in fact, it is we the people. It is government of, by, and for the people. They also quote our third president, Thomas Jefferson, who framed this matter this way. He said, I consider trial by jury as the only anchor yet imagined by man, which government can be held to the principles of the Constitution. They understood, they had a clear understanding, the Founding Fathers did, of the importance of the jury, of the right to trial by jury, and the power of the jury to make important decisions. And I want you to stay tuned because we're going to talk about this a little bit more. I want to go into this a little bit more because they've got some great examples, and I've got a link on our website. And right now we're talking about this whole concept of fully informed juries. We mentioned John Adams and Thomas Jefferson, both of whom, by their quotes in this letter that the Wilkes-Barre Independent Gazette gave to every one of the judges in Luzerne County. And they're not done. They're going to go to other judges as well. But the May 7th issue of the Wilkes-Barre Independent Gazette, the May issue, which will hit the streets May 7th, is going to be addressing this issue. Third President Jefferson said, "I consider trial by jury as the only anchor yet imagined by man by which government can be held to the principles of the Constitution." And this is what's so exciting about this, is that these are rights we already have that are well established in the common law, but not well regarded by the courts. They say in the letter that they gave to the judges, remaining in the Founding Fathers period, the case of John Peter Zenger is illustrative. He was found, quote, not guilty of seditious libel only after Andrew Hamilton informed the jury of its rights. The prosecution in the case argued that, quote, truth is no defense, because at the time it was against the law to print damaging stories about the royal governor of the New York colony, even if it was the truth. And then they asked the question. Our question to each of you is simple and straight to the point. Where do you stand on the issue? We would like to know. What would happen in your courtroom if a defense attorney were to relate this information, notifying the juries that they not only possess the right to judge the case based on its facts, but to judge the law itself? Would they be cited for contempt or face even harsher penalties? We're going to pose a hypothetical question, and one for which we'd like a direct answer. It's not intended as a typical gotcha question, but intended only to get to the heart of the matter and could clearly indicate, or should clearly indicate, your stance regarding jury nullification. Now, I've asked the guys from Sanity Check if they would let me know, from the Wilkes-Barre Independent, if they would let me know if the judges have responded, and I don't see anything in my inbox just yet indicating that they've gotten any responses, and I presume they'll probably want to hold that for the May issue of the Wilkes-Barre Independent Gazette. In most courtrooms today, the letter says, we will instruct the jury to uphold the law. The judge will instruct the jury to uphold the law as he presents it to them. Now, and this is devastatingly powerful. This is good work by the guys at the Wilkes-Barre Independent. Now, if Rosa Parks were to appear in your courtroom today, would you allow the defense attorney to inform the jury of its rights and obligations? The fact of the matter would be not in dispute. It is, or was, against the law for Rosa Parks to sit where she was sitting. If the defense attorney were not allowed to notify the jury of its rights, the jury would have no choice but to return a guilty verdict. And there's nothing that could, in my mind, there's nothing that could make this issue more clear than that case. We all know in our heart of hearts that the law was wrong, that telling Rosa Parks she couldn't sit where she wanted as an American citizen was horribly wrong. And yet, if the judge had instructed the jury, as many judges do, and we're looking for information on how that's adjudicated here in northeastern Pennsylvania, and we'll ask as many judges as we can find to answer this, Rosa Parks would have been found guilty. The jury would have said, you know what? We don't like it. We don't like the way Rosa Parks was being treated. We think the law is wrong, but the judge tells us we're stuck with it. I've included two previous editions, they go on to say, of our newspaper. And then I like this again. They started out by pointing out, this is coming out in the May issue. They say, currently we print 5,000 copies per issue and expect to increase this quantity somewhere to between 7,500 and 10,000 for the May edition. Nothing like pointing to the big stick in the corner of the room as you ask the question. We also enjoy a robust online presence, coordinating our efforts with those of numerous groups in the area. A Scranton edition of the Independent Gazette will launch in May or June. Your responses will be posted in both newspapers, among online groups, and local and national legal organizations. And then they point to an even bigger stick. We also possess a broadcast radio outlet, as Tea Party Mike and I are also heard Saturday mornings on 94.3 FM, The Talker. Thank you for your cooperation, and we look forward to your responses.